Is that the disposition? Has anyone promised you anything other than that in order to get you to admit a violation? Has anyone threatened you or coerced you in any way in order to get you to admit the violation? I need you to answer out loud. Are you entering this admission freely, willingly, and voluntarily? Are you entering this admission because indeed you violated the terms of your probation? I'm sorry, I couldn't hear you.
I said I'm pleading for this problem. They won't railroad me.
Okay, so why are you entering this admission? Because you believe it's in your best interest or because you violated your probation? All right, and so as you stand there before me, are you under the influence of any drugs, alcohol, medication, or any condition that prevents you from understanding what I'm saying or what's occurring in court? Have you had sufficient time to speak with your attorney about this probation matter? Has he answered all your questions to your satisfaction? Are you satisfied with his representation? All right, why not?
I mean, I don't feel like he's like,
Tell me.
I mean, I don't want to get in trouble.
You're not going to get in trouble, but I have to make sure you're entering this plea freely, willingly, and voluntarily with a full understanding of the nature and consequences of doing so. You're telling me you're not satisfied. I want to know why.
Because, I mean, by the state, I know there's a review, like, the evidence of my case or whatever, and seeing I ain't did nothing, and you're still, like, trying to send me to prison for nothing.
Well, the violation report and affidavit that was filed by your probation officer alleges certain violations of the probation that have been previously ordered by me and that you allegedly violated. Now, you have a right to have a hearing in this case and to make the state prove those violation allegations. Or, as you started to do today, you also have a right, if you choose, to enter an admission to those violations. Nobody can force you to do that. But that's the only two ways to resolve this matter today. Either you enter an admission or we have a hearing on it. What do you want to do?
I'd rather take this and get railroaded. I mean, you took my last case.
You were here before me, yeah.
Yeah, and it showed that I ain't done nothing. All the evidence showed that I ain't done nothing. And they, instead of dropping me, they gave me probation. Like, wow, I mean, and it's nothing, I mean, I don't understand that. If the state reviewed that case and seen that I hadn't done nothing, they didn't drop it. It just gave me, I mean, I had to take a lesser charge to go home. I had to take probation to go home. I mean, not doing nothing.
Well, you pled guilty to the amended charge of child abuse.
I had to. It was trying to get me life. With no evidence. I mean, just...
I understand what you're saying, but then you agreed to the terms, and now at least it is alleged that you're not abiding by those terms. So what do you want to do today, Mr. Henderson?
I gotta take it instead of giving, I mean, I wouldn't do that. The best thing I got.
You want to go forward with this plea?
Yes.
Despite what you said of not being satisfied with your representation?
Yes.
All right. Do you understand, as I advised you, that by entering this plea, you are giving up your constitutional right to have a hearing before this court and to make the state prove these violation allegations against you by preponderance of the evidence? Do you understand that? You're giving up the right to have an attorney assist you in that hearing. And if you couldn't afford one would be appointed to you. Do you understand that? You're giving up the right to cross-examine witnesses called against you or to present witnesses on your behalf. Do you understand that? You're giving up the right to remain silent, and you're giving up the right to appeal the revocation and termination of your probation based upon the admission you are entering today. Do you understand that? Also, if you're not a U.S. citizen, by entering this admission and having your probation revoked and terminated, you will be subject to deportation under our federal immigration laws. Do you understand that? And lastly, Mr. Henderson, if in the past you have ever been convicted of any sexually motivated offense, do you understand that by entering this admission today and having your probation revoked and terminated, that you may be subject to an involuntary civil commitment as a sexually violent predator? Do you understand that? That consequence would apply to you if you've previously been convicted of any sexually motivated offense. Do you understand that? All right. State defense, or defense you've already advised you're not aware of any DNA evidence. State, are you aware of any DNA?
There is no DNA evidence to state that we're not.
And as I stated, I have reviewed the violation report and affidavit entered October 7, 2014, and do find there's a factual basis for the entry of Mr. Henderson's admission to the violation of probation. I'll also find his admission has been entered freely, willingly, and voluntarily with the full understanding of the nature and consequences of doing so. So, Mr. Henderson, I'm going to accept your admission to the violation of probation. And I'm going to revoke and terminate your probation today and sentence you to 29 months Florida State Prison with credit for 337 days served. Do you understand that sentence? Now, you do maintain the right to appeal the sentence I just imposed if it's illegal, but you have to appeal that within 30 days. If you can't afford an attorney for that appeal, one will be appointed to you. Do you understand that? All right, sir, that's going to conclude this matter today.
And Your Honor, for the record, that was a guideline sentence for 29 months.
Okay. All right, go ahead.
David Johnson for the state. If I could call the case of James Hamilton. That is on the bottom of page 13.
All right, I'm sorry. Mr. Hamilton, you said?
Yes, Your Honor, that's on the bottom of page 13.
Thank you. Mr. Hamilton's here for arraignment, or it's not you, but it's got your arraignment.
Yes, we filed a written plea not guilty and waiver of arraignment, Your Honor. And for the record, Matthew Churchus on behalf of Mr. Hamilton. The defense is in receipt of a one-count information waiving formal reading, entered the plea of not guilty, reserving the right to challenge the sufficiency of the charging document at a later date. Mr. Johnston and I have had a brief conversation this morning, and there's probably very little discovery that we need to sort through before this case is going to go one way or another. Likely the one way. So if we could maybe get 3 weeks, Mr. Johnston's going to get the discovery together fairly quickly, and we don't need to do a whole lot, but we could maybe take 3 weeks, and then we'll be back to the court either with disposition or alternative arrangements.
All right, well, what are Mr. Hamilton's guidelines and what is speedy run?
Your Honor, Mr. Hamilton does not score speed trial runs on December 18th.
All right, we can pass Mr. Hamilton's case for his first pretrial till August the 12th.
I believe the PD's office was appointed as well.
Yes, Your Honor, we would move to a trial based on the mayor's private counsel.
Okay, PD's office will be permitted to withdraw it.
And that's the 12th, Your Honor?
It is a Wednesday.
Very good.
All right, thank you.
Thank you.
All right, anything else out of order? All right. Mr. LaPonte, are you ready to call Nathaniel Brown to page 2?
Thank you, Your Honor. I'm not sure if Mr. Fowles is here.
Oh, he's represented by counsel?
Yes.
Okay, the calendar didn't indicate. We'll wait then. All right, how about Kenneth Chapman, bottom of page 4, top of page 5? And who is is the PD's office representing Mr. Chapman on these DOCs?
Notice to appear, Your Honor.
All right, Mr. Chapman, have you hired an attorney, sir, to represent you on both of these matters?
No.
Can you afford to do so? All right, why don't we hand Mr. Chapman an affidavit? If you'll sit down, complete that affidavit. If you qualify, I'll appoint the Office of the Public Defender to represent you in these 2 cases. We'll recall your case when we do. Jerry Clark, bottom of page 5.
Never response, Your Honor.
last week, we passed it to this week, because the defendant had not gotten proper notice. Do we know if the defendant has received proper notice of this arraignment?
Royce Sullivan on behalf of Ms. Clark.
Have you had any communications with the court?
I have not, Your Honor. I am curious about if she received notice or she served proper notice for the hearing today.
This is the PTI reject statement, Your Honor.
No, I'm trying to see the correspondence. It looks like back on June 19th, in a letter, warning Ms. Clark about failure to abide by her prosecution was sent back to us. Also, the June 22nd, same thing, Your Honor, so, yeah, never.
All right, I'm going to pass it one more time to make efforts to locate her. We'll come back August 11th for arraignment. See if we can get a better address on the clock.
Thank you.
Thank you. Moving on board.
Yes, Your Honor, I just want to make sure that is in the sheet. Your Honor, if we may call the case of James Rhodes, page 25, and not be calling on behalf of the state.
All right, good morning. We are here for a ruling on a motion today following a 3-day evidentiary hearing that we held on the defendant's motion for determination of intellectual disability of the Barnett executions. Having considered the testimony of the experts and the other witnesses and the exhibits introduced into evidence, the argument of counsel, and the legal authority presented, this court has made its ruling, and in this order I am distributing to the parties. This is the original from Madam Clerk. Here's copies for state and defense, along with the exhibits attached thereto. And in short, I find that the defendant does suffer from sub-average intellectual ability, but does not suffer from deficits in adaptive functioning or behavior as a result thereof. Therefore, the defendant's motion is denied, and the death penalty will remain as a possible cemetery.
You know, I put Mr. Guy before court, and if the court would, if we could pass it till the week of August 10th, we have to file some motions, we're going to contact the experts to check the availability for trial, and other housekeeping matters that we need to take care of, and that would be acceptable to Mr. Guy as well.
All right, then we'll pass it till Wednesday, August 12th, for the next pre-trial.
And at that time, the state just is requesting we consider for trial that date, obviously, pending availability of the defense experts.
Okay, we'll go ahead and set it for trial on that date.
Thank you, Your Honor.
Thank you.